Bene, buongiorno a tutti. Siamo onorati di avere oggi ospite qui a UnitelmaSapienza il professore Jonathan Clough della Monash University in Australia, dove insegna Criminal Law and Evidence, Cybercrime and Corporate and White Collar Crime ed è direttore della Higher Degrees by Research. Jonathan Clough è uno dei più noti e autorevoli studiosi penalisti nello scenario internazionale, in particolare nell'area della criminalità economica e di impresa. Il professor Clough in particolare ha svolto studi di centrale, importanza e di diffusione internazionale su temi come i cybercrime, il funzionamento delle giurie e la responsabilità da reato degli enti. In particolare ha pubblicato nel 2015 con Cambridge University Press il volume Principles of Cybercrime e nel 2002 con Oxford University Press il testo The Prosecutions of Corporations, oltre a molti altri lavori nelle più prestigiose riviste nazionali e internazionali. Attualmente è altresì Chief Investigator dell'Australian Research Council Linkage Grant con il Victorian Department of Justice per lo studio di buone pratiche di comunicazione giudiziale con le giurie. Il professor Clough è oggi ospite dei nostri docenti, che conoscete tutti: Vincenzo Mongillo, professore ordinario di diritto penale presso il nostro Ateneo, ed Emanuele Biritteri, qui alla mia destra, ricercatore in tenure track di diritto penale, sempre qui a Unitelma, con i quali condivide molteplici interessi scientifici, naturalmente di didattica e ricerca. Le cattedre penalistiche del nostro Ateneo, guidate dal professor Mongillo, sono infatti da sempre impegnate in attività didattiche e studio sui temi più all'avanguardia, naturalmente, del diritto penale economico e di impresa. La nostra offerta formativa di corsi di laurea e master consente di approfondire adeguatamente queste materie sugli argomenti di maggiore rilevanza in tema di criminalità dei colletti bianchi e responsabilità da reato degli enti. E quindi i nostri docenti, che saluto e ringrazio naturalmente per essere qui unitamente al nostro grande ospite, autorevole ospite internazionale, guideranno per noi, per voi, un'interessante discussione con il professor Clough sui temi di cruciale rilevanza per il diritto penale moderno, a partire dalle sfide che le nuove tecnologie impongono allo sviluppo dell'economia e dell'impresa rispetto al diritto penale. I nostri sistemi giuridici hanno strumenti adeguati per affrontare queste sfide? Siamo chiamati oggi a ripensare radicalmente, in tutto o in parte, le nostre categorie e i nostri principi fondamentali. Insomma, molti gli argomenti di cui si discuterà oggi, quindi io do la parola a voi e buona intervista.
Grazie Roberto. So, good morning everyone. It is also a great pleasure for me today to welcome Professor Jonathan Clough from Monash University. As Roberto Sciarrone has already anticipated, Professor Clough is a distinguished scholar in the fields of criminal law and evidence, with particular expertise in cybercrime, corporate criminal liability, and the challenges posed by new technologies to legal systems. He's the author of numerous publications, including the leading book, Principles of Cybercrime, and he teaches cybercrimes in Monash LLM program. And over the years, he's also provided expert advice to governments on cybercrime policy and has been an active member of various international academic and professional networks. In addition, he has written several key works on corporate criminality, including, for example, improving the effectiveness of corporate criminality, all challenges in a transnational world, and failure to prevent offenses, the solution to transnational corporate criminality, ? At UnitelmaSapienza, our research group is very much engaged in many of the same areas: corporate liability, compliance, sustainability, cybercrime, and implications of artificial intelligence and digital platforms for criminal law. So, Professor Clough, thank you so much for being with us today. It's a truly privilege for us to have the opportunity to engage in this dialogue with you. And to open our conversation, I would like to start with a broader question, one that looks ahead to the future of your research and to the directions that modern criminal law might take. In particular, Jonathan, I prefer to begin from the end, so to speak, from the perspectives you foresee for the future. In the coming years, will you continue to focus on these two lines of inquiry, corporate criminality and cybercrime, or do you think that there are other areas in which it would be worthwhile to invest resources and open new directions of research?
Thank you, Professor. Thank you to you all for joining, and thank you for welcoming me. It is a great privilege for me to be speaking with you all today. I should explain to viewers, I look particularly casual. I was hoping to be there in person, but we were unavoidably delayed, so I'm holed up in a hotel room at the moment, so I apologize for that. In terms of future directions of research, I think this is an incredibly exciting time to be a criminal law scholar. The short answer to your question about the areas I research, I would suspect so. We'll come back to this, but corporate criminal liability in particular, to be honest, I had lost a lot of interest in for a while because in common law countries, it was just neglected. It was said to be impossible. There was so little interest in it practically. And that's changed in more recent years. And it's very exciting to see in Europe, Italy in particular, and many jurisdictions around the world becoming more engaged with corporate criminal liability. And I think that's very exciting and a welcome change. And I'll come back to some of that later. Cybercrime, what I've found with my research is, in some ways, it's narrowed. My particular focus now is on the law enforcement mechanisms that support prosecution. So my particular focus has tended to be on child exploitation prosecutions, less about the offences, more about how law enforcement actually go about securing prosecutions for crimes which are transnational, have incredibly sophisticated offenders, and are obviously incredibly serious. So that's the specific focus. But if I was to highlight just as an opening some areas that I would focus on, or say are good areas to focus on, one is harmonization. And this is so exciting and why we have these conversations. For too long, I think we had this big divide between common law countries, civil law countries. And the fact is we face the same challenges. In many respects, we do things quite similarly. And when we do things differently, it's great to ask, why can't we do it that way? What stops us? It's so invigorating to learn other perspectives with an open mind. Practically, it's vital. Corporate crime, transnational cybercrime, because they're transnational, it's absolutely vital that law enforcement be able to cooperate effectively. And to do that, you have to break down the barriers between those legal traditions. And we're seeing that more and more. And I think that's a really important area to focus on. We have to avoid the delay. It's too slow. And Europe in particular can teach us so much, because Europe has so many legally diverse and culturally diverse countries. You've been cooperating with law enforcement for many, many years. You have mechanisms in place that we can learn from, that I think is really important. Secondly, civil and criminal liability, particularly in commercial law. So from an Australian perspective, as I said, we've given up on a lot of criminal liability with corporations. We use a lot of civil liability. I find that quite frustrating. And there's a need, yes, it's easier, but there's a need to think about, when do you need the criminal law? In civil law countries, your tradition of criminal liability for corporations is relatively new, but because of your legal culture, you have to think about it much more clearly about, can we impose liability on corporations? How do we do that? And I think there's a really interesting area for reflection there. Third, The fact is, criminal prosecutions, particularly for transnational crimes, are not going to happen except in the most serious cases. It's simply too resource intensive and there are too many crimes. If you think of the sheer volume of fraud in the world, the number of prosecutions that are happening are going to be tiny compared to the number of crimes. So what we need to focus on are non-prosecutorial measures. How do you deal with crimes in other ways? And that can be crime prevention through technology. That can be disruption, so using technical means to disrupt criminal networks, using tax laws, confiscation of proceeds of crime to go after organized crime networks. Now, it's not strictly criminal law, but it sits very closely alongside criminal law and is absolutely essential in supporting criminal law. So those are three areas I'd highlight. We'll come back to AI, I think, so I'll stop talking for a moment. But those are three sort of broad areas that I would say I'd be thinking about going forward.
Thanks a lot, Jonathan. I agree that we face the same challenges, both as a civil law and common law countries, and this is why dialogue between us is so important. I think that your thoughts are an excellent way of framing the future challenges, especially the balance between prevention, disruption of any and transnational criminal networks, and fundamental rights is another great problem. And this brings me to the second question I wanted to ask you, the success of corporate criminality worldwide. Indeed, I think that an area of a common interest for us is corporate criminality from the early stage of the discipline in which this tool first emerged and spread primarily within common law systems of common law countries. We have made significant progress on both the scholarly and institutional levels. Today, many countries, including those within law tradition, have long since adopted legislation in this field. Italy as well. And your opinion, what factors have contributed to the success of this discipline in countering corporate crime in the last few decades, in the last few years?
I think it's a really interesting question, and I'll go back in time from a common law perspective, and I hope everyone understands I'm not coming here saying that we do things right, and this is one area where I don't think we do things right. Part of the genius of the common law is supposed to be it's very adaptable. Judges can adapt the law. This is not our great example of that. It has, although we've had corporate criminal liability for over 150 plus years, it's developed in a piecemeal, so just I don't know if there's an Italian word for a piecemeal fashion. You have to wait for particular cases to come up. The decisions were not very helpful, and it just created this environment that it doesn't work. And that's unfortunate. It is absolutely an area that should be considered by the legislature and thought about very carefully, which is, I think, an advantage for many countries that have come later to this tradition. And we have statutes, of course, but I think we come from a background that just felt it was all too difficult. The success you can talk about on a number of levels. The international uptake is primarily driven by the UN Convention on Transnational and Organized Crime and bribery conventions. And particularly around bribery and money laundering, because they require liability of legal persons, then countries have had to adopt that because they have acceded to those conventions, and they are widely adopted conventions. So that's an amazing change that it's adopted throughout the world. Now, why did that happen? It seems to me, and I hope it seems to me, partly this was driven by the weight of the United States in particular and other countries really pushing for those conventions to be adopted. And not just corporate criminal liability, but countries are judged on their foreign corruption, on their bribery regulation. And so there's a real incentive for them to actually do it because there's a real push for that. So I think it was largely driven by that. Is it successful? Well, I think that it's early days to judge, and you could tell me better. One observation I would make as a newcomer is it seems to me that what I've observed of Italian provisions and what I understand of them is that they are innovative. Comes back to my earlier point. You're not stuck in history like we were. You come at it fresh, particularly around organizational fault, and especially something dear to my heart, which is sentencing, taking a different approach to how you sentence corporations, having a whole range of sentencing provisions in place. So I think there's enormous scope for it to be successful. And I've spoken to people in other jurisdictions around Europe in particular. Again, they're not caught up with the history that we have. They just think, yes, we could impose liability on a corporation and that would be useful for this purpose. The third aspect of success, which worries me, and may be true in Europe as well, is there is too much focus on financial crimes. Mm-hmm. Because it comes from that history of foreign corruption, bribery, money laundering. The focus is on those offences. It's certainly true in Australia and many common law countries. And that is to the expense of other areas such as human trafficking, environmental crimes, which are extraordinarily serious and pressing offences, but certainly, and I'll talk about this a bit more later, I think is neglected. And I think the success is limited there. So that would be my 3 points.
Professor Clough, I fully agree with you that corporate criminality remains underutilized today in relation to certain forms of wrongdoing that we might probably regard as business crime or corporate crime in the strict sense, environmental crimes, human beings trafficking. And in addition, I'm particularly pleased by your recognition of the role played by Italy in shaping some forms, some of these models of corporate criminality, in particular, a model of corporate criminality based on an element of organizational fault. And in this regard, in recent years, you have devoted much of your research to the failure to prevent model. And about this topic, which features do you believe make this model an effective instrument in the fight against corporate crime, including in its transnational dimensions? And conversely, what do you regard as the weaknesses of this model of enforcement? And finally, do you consider that the adoption of negotiated settlements for the resolution of such proceedings is an unavoidable step for jurisdictions that choose to embrace this model of corporate liability?
Thank you. The failure to prevent model, which I suppose we would say is, and I'm not saying it's only here, but from a common law perspective, really came out of the English foreign bribery provisions where they adopted it most clearly, is incredibly, well, it's not just promising, it's been effective. To understand that from our point of view, I need to put it a little bit into the history. I won't go too long into the history. Interestingly, failure to act was the very first form of corporate criminal liability back in the 19th century, back in the Industrial Revolution, when back in those days it was railway companies that were the big, powerful companies in England, and they were going through people's land, and it was sought to stop them, and they were prosecuted for failing to take action. And it's such a small footnote in history. But the thing about almost the entire history of the common law and corporate criminal liability is, how do you make a corporation liable for the conduct of individuals? We've agonized about individual liability and attribution for our whole history. In a way, at least part of the answer was right at the beginning. Companies cannot act in their own right. but they can fail to act in their own right. And it's such a simple point, but it is at the heart of understanding this. As a matter of language, I'm presuming in Italian, it makes perfect sense to say the corporation itself failed to do something. It's under an obligation, it did not do it. And so we've agonized for over a century and have all these models about which person represents the company. In the United States, it's effectively anybody, any employee. In Australia, Canada, New Zealand, it has to be a senior manager. That is effectively useless in terms of our prosecutions for serious crime. Failure to prevent says, no, forget that. The corporation is under an obligation to prevent harm. It has failed to do so. It is prosecuted for that failure. Mm-hmm. So it has the benefit of being simple. It has the benefit of being logical. It is based on organizational fault. It doesn't choose a person as representing the company. It says, what did you do? What did you set up? And did you take reasonable steps to ensure compliance with the law? Did you take... Now, I should make this point. Of course, the offence is still hooked into an individual. Someone has to commit bribery, for example. And under the failure to prevent laws, any associated entity, that's employee, agent, anyone doing business with the company, any subsidiary commits bribery, and the offence is activated. So you have to have that predicate offence. You have to have a bribery committed. But once you do, the question is, did the corporation take reasonable steps to prevent that happening? They don't have to prevent it. Obviously, they didn't. Just did they take reasonable steps to prevent it? That's all. The onus of proof is on the corporation. That's unusual for us. We normally don't have what we would call a reverse onus provision. Normally, the prosecution would have to prove that they did not take reasonable steps. They have to prove that they took reasonable steps. And I'll come back to that. That's a strength and a weakness. From a prosecutor's point of view, that's a strength. And so in the examples that you've seen, particularly coming out of the United Kingdom, absolutely egregious fraud and corruption over decades, there's no way the company can show they took reasonable steps because they didn't. And so they will be liable for the offence of failing to prevent. So what are the problems with it? Well, I don't think this, but an argument is that we in the common law generally don't like reverse onus provisions. We have a strong tradition that the onus of proof is on the prosecution. This is an interesting issue generally around human rights and liberties and corporations. It is important, we all know, a legal person is not a person. Human rights are human rights. And yes, there are rules of fairness, and the reversing the onus, to me, is not so problematic when it is applied to a legal person as opposed to a natural person. That is because they are not entitled to all of the rights that a person is entitled to. But even more in this case, they are uniquely placed to prove what they did. These are corporations, these are structures that the corporation has deliberately, no doubt, paid lawyers a lot of money to establish in multiple jurisdictions to maximize their profit, to minimize their regulation, to minimize their cost. They are well aware of what they have deliberately set up. They are aware that they are under an obligation not to engage in foreign corruption, not to engage in forced labor. It seems to me not a big ask of a corporation to say, in all of that, did you take reasonable steps? That's all, just reasonable. Doesn't have to be perfect, just has to be reasonable. So I have little sympathy for the reverse onus argument, as you can gather. The second criticism, which makes me want to pull my hair out, which is that some scholars are concerned that, well, they're not actually convicted of bribery, that it doesn't reflect the criminality. And I understand that. But I also understand decades of failed prosecutions. We get nothing. You are better off having a prosecution for a lesser offence than no prosecution for the serious offence. If we hang on to the let's get them for bribery, it's not going to happen. This will happen. This does happen. It's worked, which to me, I know it's a criticism, but is an extraordinary strength, it seems to me. Now, the one challenge that I particularly grapple with here, which is true of all transnational corporations, is proof of the foreign offending. So you still have to prove that the associated entity engaged in the relevant crime. And any transnational issue will be difficult to prove. Having said that, in the examples that have occurred, such as Rolls-Royce, for example, and Siemens and others, it is such systematic, egregious offending, there is clearly evidence. Proof is not the problem. There may be cases where it is harder to prove, but the failure to prevent model makes it so much easier than any other model we have. The questions are much simpler. As long as you can prove that foreign bribery, then it falls to the company to prove what it did to avoid that. So that to me is one of the big challenges from just a logistical, practical point of view. But I think the model is very effective for all of those reasons. Now, negotiated settlements. I think this is it's a really interesting issue about corporate liability that I'm in two minds about. If I take the case of Rolls-Royce out of the UK, an internationally recognized brand. I think most people know the term Rolls-Royce. Certainly in English-speaking countries, it is, it's how you say something is the best, something is Rolls-Royce. To discover that a company of that stature had been engaged in this type of conduct over so many years was pretty extraordinary. Now, they have a deferred prosecution agreement, and the judge who was assessing that agreement made the point that, well, in his view, he said initially when he looked at the material, he felt that if this conduct was not prosecuted, then no conduct would be. It was so significant. But it was approved, the DPA. And the point is this, and I have to accept this. As much as I think there should be prosecution, the point of going after corporations is to bring about change in the parent company. And if you can genuinely get that company to change and you are satisfied, because companies, unlike people, can change. You can change an entity, you can change its structures, you can measure it, you can check it, you can regulate it. And if that is done, then you have achieved the goal of what you set out to do. There is a part of me that still feels that the prosecution should be punished, but I have to remember it is not a person. The issue there becomes deterrence. The reason to punish the corporation, even if they have changed, is to encourage other companies to change. And I think that is the strongest argument for why you would still prosecute it and not negotiate, is for the deterrence value. Having said that, I don't think any major corporation wants to go through this process, even if they are not prosecuted. The bad publicity, the scrutiny, I think that is probably achieved. No one wants to go through that process. To your initial question, I think negotiated settlements will be a feature of all corporate prosecutions. From the regulator's point of view, it's less resource intensive. You get the change, you achieve your goal, and that seems to me it will be a feature. But overall, I think that's a positive, but they will not happen unless you have a prosecution. What makes them negotiate is they are going to be prosecuted, and they are in danger of actually being prosecuted. And that's why the failure to prevent offences have worked in the United States. That's why they can do these plea agreements, because they have such broad liability. You are going to be convicted. So you might as well negotiate. Sorry, I hope that wasn't too long. I hope that answers your question.
Well, very, very, very interesting, Jonathan. I fully agree that the strength, first of all, the strength of the failure to prevent model lies in its focus on organizational fault and on incentivizing genuine corporate reforms. At the same time, I have to say that differently from a common law, for example, UK approach, in many continental systems such as Italy and Spain, for example, the reverse burden of proof is still perceived as unfair, even for legal persons, not only for individuals. That said, I share your view that overall, the failure to prevent model offers a pragmatic solution, and that negotiated settlements can be effective, provided can be useful, provided that they are not seen as too lenient at the expense of honest companies. Is very important from my point of view as well. And I think that the real objective of a corporate criminal liability must be not only punish the corporation, but also quickly achieve the positive purposes of the system. For example, in Italian system, the main purposes are reparation, reorganization of the company, and restitution of illicit profits. It's certainly not easy, especially considering the complexity of today's supply chains. And in this regard, you mentioned, for example, the problem of parent company liability. I think that in recent times, the issues of sustainability and accountability of a major corporation at the top of the supply chains have assumed growing importance. It is positive, and growing importance not only with regard to what occurs within their own companies, but also in terms of the responsibility that they bear for monitoring and overseeing the conduct of their suppliers, subsidiaries, and third parties. About this question, in your view, how can criminal law and system of corporate criminality contribute to addressing these complex regulatory challenges?
I think it plays a very significant challenge, particularly going back to my earlier point, if we move away from a focus on financial crimes to other crimes of forced labor or human trafficking or environmental crimes and the like. And to pick up on one of the important points you just made, and thank you for the comments, it is important to remember, as you've identified, deferred prosecution agreements are tough sanctions. They do include very significant financial penalties, which goes back to that earlier point of deterrence, that it is not something anyone would want to go through. The parent company is absolutely vital. And I come back to my earlier point, and I'm not a corporate lawyer, so I'm probably a bit simplistic about this, but no one makes companies do this. No one makes them go and operate mines in less regulated, often quite dangerous countries, politically unstable countries. No one makes them extend these supply chains. They do it to make money. It is a deliberate choice that they undertake to increase their business, often for cheaper labor, often for less regulation. In other words, they are assuming that responsibility. They take it on. No one makes them do that. They create, as you're identifying, incredibly lengthy, often complex, challenging supply chains. It is often outside the resources or sometimes the will of countries in which they are operating to prosecute. So there may be human rights abuses, for example, in numerous countries. Certainly, for example, in Australia, around the Pacific region, fishing. So forced labour within fishing industry is a particular problem. Many of the countries affected may not wish to prosecute. They may not have the resources to prosecute. When you move back up the chain, by focusing on the parent, you can bring about change throughout the whole system. Even if an individual country were willing to prosecute, change may be minimal, change may move elsewhere. Companies are very good at moving their operations where they can to exploit lower regulation, for example, and lower cost. The most effective, expedient way of doing that is to prosecute the parent. Coming back to my earlier point, they have created this. This is not put upon them. They have established it. They are responsible for the consequences. The most effective way of doing that is to impose obligations on them. What is absolutely striking in Australia, as an example, is the contrast between modern slavery and corruption. In the context of corruption, we've introduced failure to prevent laws. In the context of modern slavery, it is an offence under Australian law for corporations to engage in modern slavery, but we have not introduced a failure to prevent law in relation to modern slavery. The United Kingdom has proposed numerous financial crime failure to prevent models in terms of tax, for example, but not human rights abuses, not human trafficking. It lends itself perfectly well. It would be absolutely sensible if an associated entity was engaged in forced labour. What did you do to stop that happening? The contrast is quite stark. There is no reason for that to happen as far as I can tell from a practical point of view. It's a political decision that's made. It seems to be in many countries. I find that frustrating because the simple answer to your point is by targeting the parent, and they do not like being prosecuted, they do not like being called criminals, is likely to produce significant change. And we have seen that in the context of corruption. We should therefore try and see it in other areas. That would be my response anyway.
Thank you, Professor Clough. I fully agree on the need to hold the dominant company, the parent dominant company, accountable for the supply chain. And I also think that voluntary compliance is rarely enough to combat modern slavery, forced labor, and other human rights violations. And about that, I recall that at the EU level, a directive on supply chain due diligence has recently been adopted precisely to address these issues. An important directive at the European Union level. So thank you very much for your reflection, Jonathan. At this point of the discussion, I would like to hand over to Emanuele Direttore for the other questions. And so the word is yours, Emanuele.
Thank you very much, Professor Mongillo. Good morning, everyone. First of all, I have to say that having this conversation with you today, Professor Clough, it's an honor for us, for UnitelmaSapienza. So in the final part of it, the interview, we would like to move to one of the main other areas of expertise for you, that is cybercrime. With the Budapest Convention, as you know, states took their first step to try to adapting criminal law in relation to the evolution of criminality in the cyberspace. Today, new perspectives are opening up, as you know, with the forthcoming United Nations Convention on Cybercrime. And the scholarly debate has focused a lot in trying to also focusing on the challenges posed by new technologies, from AI to metaverse, for example, to the fundamental principle of criminal law, and also challenges posed to the criteria for the attribution of liability. So my question is, in your view, what are the main aspects to highlight in this respect, in this field, and how should criminal law scholars, if you like, should prepare themselves to address these challenges?
Thank you. Yes, the UN Convention is really interesting. I think I'm not alone as a scholar in the area in being absolutely stunned that the UN reached agreement on a cybercrime convention. We thought it was never going to happen. And it's important that it's happened largely on a symbolic level. I'm not sure if you're aware in Europe just how negative the Budapest Convention can be in some countries. Not in Australia, not in many common law countries. We've all signed up. We're very positive. But there are large sections of the world that were very hostile to the Budapest Convention. And this was a really unproductive debate. It just held things up. And the surprising thing, or not surprising thing, about the Cybercrime Convention, the UN Cybercrime Convention, is how similar it is and how compliant it is in terms of operating alongside the Budapest Convention. There are some changes, but then they're overall, to my mind, not hugely significant. But what's hugely significant is it is there, and we have an international instrument, and we can stop debating Budapest, not Budapest. We just have an international agreement that aligns with Budapest. So I think that's really the symbolic importance of allowing countries to just move forward and start harmonizing without this false debate. Even with Budapest and the UN Convention, the number of actual offences is tiny. It's relatively small because countries can't really agree on the substantive offences. You have child exploitation, you have the hacking offences, you have fraud. But countries want to have things like terrorism offences, for example, or obscenity or political offences, and you can't get agreement on that. What's significant is the law enforcement cooperation. I mean, that's the important aspect of both Budapest and the UN Convention, is putting measures in place that law enforcement agencies can cooperate effectively in the area of cybercrime. So I think that's a really significant aspect of it. It's an area that I'm, I suppose, most interested in these days, is how we cooperate, how we make these operations work in a timely fashion. In terms of emerging technologies, I'll put AI to one side for a moment. There's a couple of lessons I'd say over decades and from the early days of the internet, is to be cautious in how we approach new technologies. It's really important to focus on the conduct rather than the technology. What is it that we're punishing? I'll give you an example. So currently, using AI to generate obscene images, image-based abuse, is a major challenge, and AI has allowed that to be done in an extraordinary way. But it's not so much the technology, it's just, it is a crime to produce an image of another person in this way. Does that make sense? It's not about, you don't have to base it on the technology. We regard it as a crime to generate an image, a sexualized image of a person in this way, regardless of what technology you use. So it's what we would say is technology neutrality. Focus on what is done. The second aspect is being very clear on things like cyberspace, and certainly in the early days of the internet, there was a lot of talk about cyberspace. And of course, there is no other place. The internet is just server farms in countries around the world. The data is based somewhere. The keyboards are being, tapped somewhere. People are looking at devices in a jurisdiction. We have to remember that these are jurisdictionally based. It creates enormous challenges. But I think talking about sort of broad notions of cyberspace is not always helpful, which takes me to AI. And I don't have any particular expertise on this aspect, but I can see it as a major challenge in two ways. One, it is going to transform all the existing crimes we have. If you think of the spam email you get or the spam text message you get, What do you usually look out for? The language isn't very good. It doesn't sound right. AI is going to transform that. The language will be perfect. The language will be tailored to you because it can be. That's going to be extraordinary. As I said, the generation of obscene images, images of children, this is all being done at the moment by AI. So there's that side of it. For people more philosophically minded than me, I think the really challenging issue is liability for the AI itself. Where does liability sit? Does it sit with the manufacturers? Are they responsible for what they have produced? Is it responsible for the person who uses the technology? What if it is then acting autonomously? At what point do you lose responsibility? If you set something in motion and it is acting automatically, at what point do you cease to be responsible? Do you cease to be responsible? There's some talk about AI as having its own legal personality. I'm frankly a bit skeptical about that, but that's certainly a view that's out there. So I'm not really adding great insights there, other than I think that is a really interesting question of where the liability sits from manufacturer to the artificial intelligence itself. It's going to be a very fruitful and interesting area of investigation. I'm afraid I don't have a great deal more to say. What I will say is that the international conventions don't really help us at all on those issues. Not the cybercrime conventions anyway. Oh, sorry. There's not an earthquake here. That was just me moving. Sorry.
Thank you very much, Professor, but I think you already gave us great, in my view, if you like, guideline, no? Focusing on technical neutrality, focusing on conduct in order to have a criminal law that can be adaptable, no? To also new emerging technologies, because I believe there is this fear, no? This concern on moving faster to change criminal law to follow new technologies, but they are going faster than us, so that can be challenging, of course. So our last question is, you already touched some of these points, but just to conclude, with regard to new technologies, do you think that we already have adequate regulatory instrument to address these challenges, or somehow in the future we have to maybe think about modifying, if you like, certain classical categories and principles of criminal law in order to adapt these categories and principles to these new developments?
I think your use of the term regulatory instruments is the key point, because it's not necessarily criminal law. I think what is scary about AI, and we saw it with the internet, and this is much scarier, is it is being released and put into the wild without limitations, without security being in mind. We learned this with the internet, that no one expected that the dissemination of child exploitation material would become one of the major, criminal activities on this new form of technology. That children would be so vulnerable because they're just given access to this type of technology. So much of crime prevention isn't about the criminal law. I think we have criminal laws that will adapt as best they can. I mean, I don't think they're perfect. They're not perfect now. What worries me far more is the crime prevention side of things, and that is partly educating people. But it seems to me we are so driven commercially, and look, we all love this technology. Give me more technology. We know it's dangerous. We're saying it's dangerous, but what check is put in place? We're just letting it go. Look at how children operate with online devices now. That was not imagined 20 years ago, right? That it would be so prevalent, that it would be so extraordinary, that you would then move into these AI-generated images, or their ability to interact with anyone via these devices. So that doesn't sound like a criminal law scholarship. In some ways it is. I mean, it has to work hand in hand with law enforcement, but these are questions we have to think about. It is being used for crime. There's just no doubt about it. Criminals will use it to commit crimes. And so I think in terms of regulation, I would be looking much more clearly at international agreement. I don't know how you would get it, But it seems to me this is running away from us very quickly, and it will get to a point where it's very hard to pull back and the damage will be done. That's a very gloomy note to finish on, I realize. But I think it is genuinely concerning how this technology will transform all forms of crime and make them easier to commit and more effective.
Thank you very much. So working globally on these issues
Absolutely.
at a scholarly level, it can be helpful, no? To give new perspective on these issues. So Professor Mongillo, I don't know if you want to add something for the last part of this conversation.
Jonathan, before we close, may I ask you one final question for the benefit of younger scholars who are interested in working at an intersection of criminal law, technology, and corporate responsibility. What advice would you give them?
Wow, that's a big question. What advice would I give them? I would advise people to, that's a really good, you've stumped me with that question.
Sorry.
The reason I'm stumped is I think of how I started. I was going to say how I started, which is I just started writing. I got into corporate criminal liability because I thought it was interesting and I started writing. And the same with cybercrime. I thought, oh, this is an emerging issue. I'm going to start writing. So I suppose my advice would be start writing, get your thoughts down, work hard at that, because to the extent that I'm any sort of expert now, it's because 25 years ago, I started writing and I wanted to put my mark on it. I didn't know that I would, but I knew that I had to start. And I focused on an area and I immersed myself. And sorry, the reason I was pausing, there were two things in my mind. One was to start writing. And the second is draw on the amazing people that you have at your universities, etc. Make use of those people that you have around you. Because in my view, I certainly am. I love hearing from young scholars who are interested and want to hear about things. I'm sure you do the same. Make use of those contacts. Get them to put you in touch with people or whatever it might be. That's how the journey starts. Both start writing, put your mark on it, and use as many contacts as you can and be serious about it. It is too easy today to get distracted by a million different issues. You can't do it. Start with an issue, become an expert on an issue. It would be my advice. Get focused and serious and it'll go from there.
I think that is a very great advice. And so, Professor Clough, thank you very much for your time and for sharing your great insights with us today. I believe our audience will greatly benefit from your reflections on how corporate liability, cybercrime, sustainability, and the challenges of new technologies interact with criminal law.
Thank you so much.
We very much look forward to continuing this dialogue and to strengthening the collaboration between our institutions. And so we hope that next time we will have the pleasure of welcoming you in person here in Rome. And thanks a lot.
I hope so too. Thank you. It's been an honor. Thank you so much.
Goodbye to all our listeners.
Thank you very much, Professor Clough, also from Unitelma here face to face. Roberto, I don't know if you want to close.
Thank you, Professor Clough. Thank you so much. Thank you to our Professor Vincenzo Mongillo and Emanuele Biriteri. See you soon. Okay?
Bye. Thank you.
Bye.
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 Ciao.
Ciao.